How much money have you spent on all this?
$100.
Yeah, and now it's going to cost you more because you will be required to pay for the DPS fines and fees and surcharges. And if you don't, I'm going to put your butt in jail. And every $100 you owe, you will sit in custody. Facing up to a year in jail and or a $4,000 fine. How old are you?
26.
26. And you now have 2 DWIs. What happens on the next one?
I don't know.
You need to know what happens on the next one.
Bad news, yeah.
No, not bad news. What happens?
Um,
I'm going to tell you now that you now have 2 DWIs going on your record. If you were ever pulled over and you have the slightest smell of alcohol on your breath, any officer that pulls you over is going to say, well, if it walks like a duck and it talks like a duck, meaning if it's got DWI 1 and it's got another DWI, it's probably DWI again and is able to withhold his tolerance. They're going to arrest you. No questions asked. They're not going to give a rat's behind whether you're drunk or not. The smell alone will be enough to take them down. And now you will be looking at up to 10 years in prison. Up to 10 years in prison. That's what you're going to be facing. I hope you really appreciate the gravity, because do you know what they would do to you in prison, Mr. McCollum? A little white boy stick piece, you know what they would do to you in prison? Holy moly, I've read stuff that was so bad it had me in freaking tears. How they just pass people along like it's a freaking rag doll. And you know what? The jailers don't give a rat's behind what happens in there. Some places are so bad they don't even go there. And I promise you, because I'm a judge, I get to read extra stuff that you're never going to get your eyes on. And it literally had me in tears, how they treat people. So you're one step away. And I hope that you appreciate that.
This is one of the most intense warnings you will ever hear from the bench, and the judge isn't exaggerating for dramatic effect. She's laying out the reality of what happens when someone accumulates multiple DWIs legally. The moment a defendant has 2 DWI convictions, prosecutors and officers begin treating any sign of alcohol more seriously. Even the smell of alcohol gives officers probable cause to investigate aggressively, and a 3rd DWI in many jurisdictions becomes a felony with multi-year prison exposure. The judge goes a step further by explaining the harsh truth about prison culture, something most defendants never think about until it's too late. She's not shaming him. She's trying to shock him into realizing that the next mistake isn't just a fine or a weekend in jail. It could permanently alter the course of his life. Question for viewers: do you think this kind of harsh wake-up call is necessary to prevent repeat offenders? Or should judges take a softer approach?
All you have to do is pick up a phone, hit one button. You'll have a car for $20, take you anywhere you want to go in this freaking city. Don't matter where you want to go. It's always $20. How much money have you spent on all this?
$100.
Yeah, and now it's going to cost you more because you will be required to pay for the DPS fines and fees and surcharges. And if you don't, I'm going to put your butt in jail. And every $100 you owe, you will sit in custody. You're now going to be required to pay somewhere to the tune of around $6,500 to $7,000. So you can imagine how much time you will sit in jail if you don't pay it. Do you understand? Because I am trying to impress on you how dangerous this type of offense is and how very important you must take this in the future so you don't end up in prison.
Here's where the judge breaks down one of the most underestimated aspects of DWI cases: the cost. Many defendants assume the fines end at a few $100s, but in reality, DWI cases generate layers of expenses: DPS fees, surcharges, program costs, probation fees, interlock installation, classes, testing, and more. The judge's estimate of $6,500 to $7,000 is absolutely realistic, and that's before accounting for the long-term financial implications like higher insurance premiums and loss of driving privileges. This commentary isn't about punishing Mr. McCollum. It's about emphasizing that DWI is a financial earthquake. The judge wants him to feel the weight so that the memory of this moment actually prevents future harm. Viewers, let us know. Do you think financial penalties are effective in stopping repeat drunk driving, or should consequences be more treatment-focused?
What are we doing, Jay?
They reduced it to a Class B misdemeanor, DWI first, interlock, 18 months probation, and TRAS, all the conditions that go with the TRAS.
180 days in jail to be probated for 18 months. As part of the probation, you will do a repeat offender DWI education class, 2 victim impact panels, a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. If they tell you that you need to do inpatient treatment, well, that's where you're going to go. If they tell you that you have to do intensive outpatient or SOP, then you must do those as well. If you don't, then guess what happens? I will issue a warrant for your arrest, and then you will be looking at 180 days in jail. And I myself, if I find that you're consuming alcohol while you're on this probation, I will put you into treatment myself. And I'm going to tell you, it lasts for 180 days if you respond to treatment well. If not, you can be in there for a year and a half. Do you understand? I just put someone in yesterday, and they're going to be in there for a solid 6 to 9 months, maybe a year and a half. You understand?
This is where the judge gives a crystal clear breakdown of probation, and she makes it absolutely unmistakable that this is not optional, casual, or flexible. A repeat offender DWI program is intentionally rigorous. It forces defendants to confront their behavior through education, victim impact panels, and substance evaluations. And when she says, if you don't, I will issue a warrant, she means it. Judges take probation violations personally because they view probation as a second chance. A chance that some defendants waste her threat of 180-day treatment isn't just punishment, it's rehabilitation through structure. Courts often refer defendants to long-term inpatient programs when they show patterns of risk. That's why she describes previous cases where people remain in treatment for months or even over a year. If you were in his position, would you comply fully, or do these strict terms seem too overwhelming? Comment your thoughts.
No drugs, alcohol, random urinalysis, guardian interlock, no breath test refusal, meaning that if you take a breath, if you're driving in a car and an officer asks you to submit to a breath test, you must submit to a breath test. If you don't, you're in violation of this agreement. Do you understand? You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, right to be arraigned, charged read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, there's no turning back. You now at 26 have 2 DWIs on your record. Do you understand? How do you plead to this offense? I will find you guilty. I am going to suspend your license for 1 year. JL, what happened on the,
We won.
okay. You guys can apply for an occupational license. I want to know that he's doing well. And I don't think that we've had any violations so far, correct?
No, sir. And Judge, just to be clear, so when we get the occupational license, and Dustin King will be doing that part, and he has to go get the interlock on his vehicle. He's gonna have someone else to drive the
Correct.
vehicle to the facility to get the interlock, because you cannot drive without an interlock,
As of
period.
this moment, you may not drive. Your license is suspended. If I catch you in a car driving, and we're going to have you sign an affidavit promising us you're not going to drive before you leave here. If you drive, you will be doing a substantial amount of time in jail. I don't care what your excuse is. I don't care if there's a burning building and you have to save 15 kids. Mother Teresa needs a ride to church. I don't care. Do you understand? Okay.
This is one of the most critical warnings in the entire hearing. Do not drive without an interlock or while suspended. Judges hear excuses every day: emergencies, family needs, even claims of just a quick drive. But from a legal standpoint, none of those justify driving while under a suspension tied to a DWI conviction. The judge lays out exactly how serious this is by saying she doesn't care if there's a burning building or someone needs help. The rule is absolute. This isn't cruelty, it's public safety. Driving without an interlock puts everyone at risk because it removes the only safeguard ensuring the driver is sober. And when she mentions signing an affidavit, that's legally binding. Violating it isn't just a violation. It's a direct challenge to the judge's authority, often resulting in jail time viewers. Do you agree with zero-tolerance driving rules for repeat offenders? Why or why not?
Yeah, jail. If he does well, and he's been doing well so far, that's good news. So we want to know that you appreciate the gravity of this offense going forward. The idea is that you have such a miserable experience here that you remember us 15 years down the road, 20 years down the road, you have some kind of catastrophic event in your life that causes you to go out, you get blitzed. You know what? I better not get in this car and go home. That was such a miserable experience. Huh? Yeah, he's gonna have to pay. What are court costs now? Was it a breath test or was it a blood test?
He volunteered breath, it's a 0.145.
Okay, so 6,000 and then plus court costs.
Even that it was reduced?
Yes, yeah. I will give you time to pay it. Okay, I will give you, 2 years, so it's not gonna break your bank, right? Because I understand, but I want you to understand that you're not gonna get out of this scot-free. And I want you to appreciate this. You understand?
So surcharges apply even though it's not time served.
Correct. Yeah. Good luck.
Thank you.
Thank you, Your
Right.
Honor.
Dale. Morning, Mr. Eli.
Morning.
Speak English?
Yes,
How's jail?
not so bad. It's pretty good.
Looks pretty rough.
Yeah.
Looks like you're having a rough time, huh? Mr. Eli, on 9/2 of 22, you pick up a false report. You blow us off. Not once, not twice, but I've got your bond at 5,003 on that one. While you're out on the land, you've now picked up a DWI second. You also pick up a failure to stop and give information. On both of those cases, you're facing, well, on the DWI, you're facing up to a year in jail and a $4,000 fine. On your FSGI, which is basically leaving the scene of an accident, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On May 2nd, 2024, officers were dispatched to a convenience store in regard to a shooting in progress. Upon arrival, they searched for the vehicle, which had already left the store. Complainant Tamika reported that she was at the store when the defendant came in, and he was acting erratically, stumbling, seemed to be under the influence of something, and kept saying, "Why are you guys always fucking with me?" unprovoked. He went outside, got a gun out of his car, and fired once in the air. She described him as, yes, Your Honor. She described him as acting weird, like he was on something, and she saw a gun fall out of his waistband, saw him pick it up, and saw him leave the store, get in his car, and leave, and back into her car, then drive off. He came to a stop at 1900 Commonwealth, got out of his car, and came into another occupied car, and went to the same location and got out and started yelling. The total damages to the vehicle were $500. Defendant was taken to Bentall because he was hyperventilating and he had a high heart rate. No firearms, narcotics, or alcohol were in the vehicle. Medical results returned. Defendant was positive for opioids, cocaine, and benzodiazepine. At the time, he was admitted to the hospital.
Eli, I'm going to find that there's probable cause to go forward with your case. I'm extremely surprised that they didn't charge you with the gun case, aggravated assault, who knows what else. I am now revoking your bond on the false report, the first case, and I'm going to raise it up to 30,003 because you scare me. You are a complete and utter danger to the public and have no business. Do you understand? If you get out of jail, I am ordering you under home confinement and doing AA and NA classes 5 times a week with a GPS monitor on one ankle and a scram bracelet on the other. And you were to remain home all day, every day. And the only time you can go out is either to a hospital or to meet with your lawyer. Do you understand?
The shift from the DWI case to Mr. Eli is dramatic, and the judge reacts with immediate concern. And for good reason. Eli isn't simply facing a missed court date. He's being described as erratic, stumbling, allegedly firing a gun, backing into someone's vehicle, and testing positive for opioids, cocaine, and benzodiazepines. This combination is volatile and dangerous. You can hear the judge's disbelief when he says he's surprised he wasn't charged with aggravated assault or a gun offense. This tells us something crucial. The judge believes his behavior met the threshold for more serious charges. That's why his bond is raised, not revoked. The court is signaling that his risk level has skyrocketed. The conditions he adds, home confinement, daily addiction meetings, GPS monitoring, and scram alcohol testing, are some of the strictest bond terms available. They're used when a defendant poses a genuine risk to the public. Question for viewers. Do you think the judge was right to increase his bond to $30,000? Or should he have gone even higher given the described behavior?
I had no gun on it.
I'm also ordering as a condition of your bond not to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what your excuse is. If you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you get into a car and drive. Tell me, how long have you been in jail, Mr. Eli?
2 days,
Are you still coming down?
yes,
How is it?
pretty terrible.
Sucks, right? Yeah. Especially when you're on opiates. It's probably one of the worst come downs you can have. You're lucky you're not seizing. I'm going to tell you now, Shreya, that I'd like to do a TRAS on Mr. Eli. And I'm not going to entertain any offers until we do it. And I need to know if he needs treatment into a facility based on his priors. I mean, this has been going on for the last 5 years now, where he's been using hardcore substances. And I'm really afraid that you're going to kill someone. You're on something. You allegedly have a gun. You're shooting it into the air. What goes up must come down. What if it comes down on a 5-year-old's head, Mr. Eli? Who gets charged with murder? Who's looking at life in prison? Do you think of these things? It's high time you did, because that's kind of behavior where you didn't mean to do it. I didn't know that what I was doing. I was doing it. And then someone's looking, and even though you don't get life, you still might get 40. Typically, when I see these cases, it's 30 years gone. Do you understand, Mr. Eli? I will have you come up here, swear to us that you're not going to drive, and then we'll have you placed back into the jail, and we're going to have you evaluated, and then we'll go from there.
These two cases highlight two very different defendants, but one consistent message. The courtroom is where accountability becomes unavoidable. In the first case, Mr. McCullum received a stern but structured path forward: probation, interlock, treatment options, and a long list of conditions designed to keep both him and the public safe. His case reminds us how thin the line is between a second chance and a felony that could carry years behind bars. In the second case, Mr. Eli represents the kind of escalating risk judges fear most: substance use, dangerous behavior, missed court obligations, and public endangerment. The judge's decision to raise his bond and impose strict confinement conditions reflects her responsibility to protect the community while giving him a chance to confront his addiction. Both stories show the balance judges must strike between punishment, rehabilitation, and public safety, and how quickly circumstances can spiral when defendants ignore warning signs. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.